Good day, Crime Talk aficionados. It is Thursday, and we have another great show for you today. First, did some poor medical decisions seal the fate of the Reiner family? Ashlee Buzzard, the mother accused of murdering her daughter, appears in court. Prosecutors reject claims of conflict in the death penalty decision for Luigi Mangione. A judge restricts some expert testimony in the Kouri Richins murder trial. An Oregon man pleads guilty to having his dead girlfriend in his trunk. A story about a judge who lacks, well, let's just say judicial temperament. We got this day in legal history, our quote of the day, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and remember, you can check us out on any of your favorite podcasting apps. Now, before we get started, yesterday or the day before, we said that whoever made an order of merchandise, they would be in the drawing, a random drawing for a $100 crisp dollar bill sent to them. And Gloria from Arnold, Missouri ordered a keychain, $5. And guess what? She got a $100 bill. So she basically got this for free and made money. There you go. See, when we say we're going to do something, ladies and gentlemen, we do it. And go check out all that merch stuff below. Let me also remind you for you to go to CrimeTalkPrep.com. There, ladies and gentlemen, you can sign up for your emergency food supply. Let's face it, we are in some crazy times, and whether it's a natural disaster, or something else that could be coming our way, you just never know. You want to be prepared. If there's a storm and there's a run at the grocery store and it's a blizzard and you don't have any food because you didn't get there because you were too busy working, what are you going to do? You want to be able to take care of yourself. Go to CrimeTalkPrep.com. Get your emergency food supply today. You're going to be happy that you did. All right, let's go ahead and open the record for Thursday, January 8th, 2026. And yes, well, there's some poor medical decisions that sealed the fate of the Reiner family. So we know that Nick Reiner had mental health issues, but in some developments tied to the high-profile case regarding Nick Reiner, obviously accused of murdering his parents, Rob Reiner, and his wife, Michelle Reiner. According to sources, there were some recent alterations in Nick's psychiatric medications that may have contributed to his mental deterioration. Now, this information emerges ahead of a forthcoming documentary exploring the incident. Now, Nick Reiner, diagnosed with schizophrenic disorder back in 2020, experienced symptoms combining elements of schizophrenia, such as delusions, hallucinations, and disorganized thought processes with mood disorders, including episodes of mania and profound depression. Now, according to informed sources, Nick had achieved stability through his prescribed medications in the period leading up to the tragedy. However, about 1 month before the event, medical professionals opted to modify his treatment regimen. Now, the rationale for this adjustment remains undisclosed. Those sources who apparently are in the know indicate it has an inexplicable choice that would astonish observers. Now, this shift reportedly precipitated a rapid decline in Nick's condition, manifesting as heightened agitation, unpredictable behavior, and escalating threats. Now, Rob and Michelle Reiner obviously witnessed these changes, expressed significant concern, but were uncertain about appropriate interventions. Sources further note that healthcare providers made no efforts to initiate a psychiatric hold during this adjustment phase, which might have allowed for closer monitoring and stabilization. Now, this sequence of events could form the core of Nick Reiner's legal defense strategy. And under California statutes, an insanity plea does not require proof that the defendant was unaware of moral distinctions between right and wrong. Rather, it suffices to demonstrate a lack of comprehension regarding the nature and consequences of the actions committed. Now, these details are going to be set out in a documentary that TMZ is putting together, and it is going to air on Fox 8 p.m. p.m. on January 9th. Now, this production is apparently going to aim to provide further insights into the circumstances surrounding the case. Now, ladies and gentlemen, obviously this is probably going to be one of the major focus that the defense is going to look at, whether it's a defense for not guilty by insanity plea or obviously mitigation that would result in some sort of a beneficial plea for Mr. Nick Reiner. However, the prosecution is going to say, no. Let's take a look at his actions before, during, and after, right? He's in the guest house, apparently has the ability to walk over, get a couple of sharp objects, go to his parents' room, slice and dice them up, and then go back, leave the house, go to a hotel across, several blocks, minutes away, miles away, and then all of a sudden be apprehended later that morning. So those factors are going to look at it and say, is this guy just, you can't blame everything on the drugs or the lack thereof. But this is where it's going to get interesting. Now, obviously, we talked about it yesterday. Alan Jackson, the private attorney who said that he was going to represent Nick Reiner from the beginning, got off the case. Now, the more I've thought about this, and we discussed it a little bit yesterday, I believe Alan Jackson did something that, most people wouldn't do. I think, and understand, I hate speculation, but listen, an attorney of Alan Jackson's, let's say he quests for attention to have that big case. And I get it. You want to have the big case, right? If you're the attorney, you're like, I want to put me in, coach. I want to play in the Super Bowl. Give me the ball, right? But it all just happened a little too quickly that I think that's nobody from the family actually went to Alan Jackson and said, would you represent this guy? I think he went in there, probably introduced himself and said, hey, you need an attorney. I'm here to help you. We'll worry about all the details with the payment in, a little bit later. So he shows up to first appearance. The arraignment gets continued. During that meantime, Alan Jackson's like, hey, this is going to be an expensive case. We're probably talking a couple, million at least, not, with experts, time, etc. Death penalty case. We're going to need money. Who's going to pony up? Remember, it's always about the money. And the money apparently didn't come. So Alan Jackson got off. There's no indication that there was a conflict of any type. He just wanted to get paid like any attorney would. And so that's what I think happened. Now, do I have proof to back that up? No, but I think it'll come out in the future that there was never any sort of engagement by the family of the Reiners for Alan Jackson to go and represent Nick Reiner. I think he did it on his own, hoping that somebody would pony up the bill later on. Obviously, it didn't happen. The family didn't say anything negative about Mr. Jackson. They just said he was a professional. He was a real pro. Didn't say we didn't work it out. We sought him out. Nothing along those lines. So we'll see. Like I said, I just don't think anybody from the family ever retained him. A lot of people asked in the comments, why wouldn't an attorney, though, do this for free for the publicity? No. I think I've told this story before. I had a case once. I remember I'm sitting in bed watching the evening news, and there's my client that I currently represent accused of a very serious crime. And I'm a younger attorney trying to get my practice going. I need that free publicity, right? There's no such thing as bad publicity. And it was a very serious sexual assault allegation where my guy allegedly broke in and sexually assaulted an elderly woman. And I thought this is going to be great. It was all over the news. It's going to be fabulous. All the publicity, the new cases that I'm going to get from it didn't materialize at all. And I wound up working my butt off on that case. I wound up paying to have investigators and expert witnesses in that case, because if you do it even pro bono, you have to do it competently. And you got to do whatever your attorney would do. Otherwise, you could be found ineffective down the road. So learn from that. Never do a pro bono case ever again. And frankly, you do enough cases where clients stiff you at the end and they don't pay their bill. So good for Alan Jackson for getting off. As they say, it's better to have not done the work and not got paid than to have done the work and not got paid. All right, next on the docket, Ashlee Buzzard That's right. The mother accused of murdering her daughter appeared in court. Ashlee Buzzard, the 40-year-old California woman accused of fatally shooting her 9-year-old daughter during a road trip last year, made her second court appearance since her arrest on Wednesday in a Lompoc courtroom filled with observers. Now, Buzzard, who has pled not guilty, is charged with first-degree murder in connection with the October 9th death of her daughter, Melody. The charges include special allegations for discharge of a firearm causing death and a special circumstance of lying in wait. She is being held without bail at the Northern Branch Jail in Santa Maria. Now, during the hearing yesterday, Buzzard waived her right to a preliminary hearing within 60 days, meaning the proceedings will not occur until April sometime. Prosecutors have stated that they will not seek the death penalty in this case, and the defense has requested a permanent gag order to prevent law enforcement from releasing further details about the investigation. Now, this motion, along with a separate request for additional information from search warrants, is scheduled to be addressed at a hearing on January 21st. Now, as you may recall, this case began back in mid-October when school officials in Lompoc reported Melody's extended absence, prompting a multi-state investigation. Police have alleged that Buzzard was uncooperative and provided no information about her daughter's whereabouts. And according to investigators, Buzzard shot Melody in the head during a road trip and abandoned the child's body in a remote area of Wayne County, Utah. Melody's remains were recovered in early December. Next, the prosecutors in the Luigi Mangione case have nothing to say nice about the defense. That's right. Federal authorities have strongly rebutted allegations from the legal team representing Luigi Mangione, the suspect in the fatal shooting of the United Healthcare CEO Brian Thompson, describing their assertions of a conflict of interest involving Attorney General Pam Bondi as unfounded and completely inaccurate. So in filings filed Wednesday, Deputy U.S. Attorney Sean Buckley for the Southern District of New York argued that Mangione's defense attorneys erroneously suggested Bondi maintains an ongoing financial interest in Ballard Partners, a lobbying firm that she formerly partnered with, whose clients include United Health Group, the parent company of United Healthcare. Buckley clarified that Bondi retains only a retirement account containing previously earned compensation from her time at the firm, with no further contributions made since her departure. He emphasized that without any current or prospective financial benefit linked to the case, no actionable conflict exists. Now, Mangione's attorneys have contended that Bondi's prior association with the firm and her directive to pursue capital punishment in the federal case against their client constitutes a significant ethical breach, potentially infringing on the constitutional rights of Mr. Mangione. Now, they have requested that the death penalty be removed as an option and certain charges be dismissed. A hearing is set for Friday. Now, the prosecution further noted that Bondi's earlier commitment to recuse herself from the cases directly involving Ballard Partners or its clients does not apply here, as neither the firm nor United Health Group is a party to the criminal proceeding. And any indirect interest the company might have in the outcome does not qualify it for such considerations, according to the government's argument. Now, the defense team declined to provide comments on the latest developments. And obviously, this case goes back to December 4th of 2024, involving the shooting death of Brian Thompson outside of the Manhattan Hotel, where he was attending an investor conference for the United Healthcare Group. Video evidence captured a masked individual approaching Thompson from behind and firing multiple shots. Ultimately, shell casings recovered at the scene bore inscriptions referencing industry criticism of insurance practices. Now, Mangione, a 27-year-old graduate of an elite university from a prominent Maryland family, was apprehended on December 9th at a fast food restaurant in Altoona, Pennsylvania. He faces murder charges in both federal and New York courts and has entered a not guilty plea in both jurisdictions. The state case could result in a life sentence if convicted, and while no trial dates have been established for either proceedings. Now, back in April of 2025, Attorney General Pam Bondi instructed federal prosecutors in Manhattan to seek the death penalty, characterizing the incident as a deliberate and shocking act of violence. Mangione's defense team has previously challenged the death penalty pursuit on grounds that it was influenced by political considerations rather than legal merit. And they have also alleged that public statements made by Bondi and procedural irregularities, including the handling of Mangione's transfer into custody, compromised the fairness of the case and the subsequent grand jury indictment. Now, the federal proceedings have regained attention following an extensive evidentiary hearing in the parallel state case last month, where the defense sought to suppress items seized during Mangione's arrest, including the firearm linked to the crime and written materials outlining his alleged motives. A decision on that motion is anticipated in early May. The defense is now urging the U.S. District Court to preclude capital punishment, to reduce the sentence and the scope of the charges, and to exclude contested evidence from consideration. Now, ladies and gentlemen, this is death penalty litigation. Death penalty litigation is knock down, drag out. They throw the kitchen sink. And as you will see, as you probably noticed in other death penalty litigation that we've talked about over the years, what is it? Just like in the Brian Kohberger case. Oh my gosh, Judge, they didn't turn over some discovery that we thought we were entitled to sooner. The sanction should be dismissal of the death penalty. That's what they do. All right? Death penalty litigation, it's all about making the death penalty go away. We talked about the motions hearings in the state court. I find it highly unlikely that the court will suppress that evidence in the state court matter in New York. Also find it highly unlikely that the federal judge will do it as well in the federal matter. So we'll see. It's litigation. It's nothing personal, but the attorneys are throwing jabs. They're throwing everything out there saying, oh, there's a conflict of interest. Throw out the death penalty. Not going to happen. Not going to happen. Next, Kouri Richins murder trials coming up, and the judge has made some rulings regarding expert testimony. That's right. The judge has issued significant rulings on the admissibility of expert testimony in the high-profile murder case against Kouri Richins, who is accused of fatally poisoning her husband with fentanyl back in 2022. Now, during a hearing Tuesday, Summit County District Judge Richard Mezick addressed several defense motions seeking to exclude prosecution experts under Rule 702, which sets standards for the reliability and relevance of scientific or specialized testimony. The court placed strict limits on behavioral threat assessment experts, permitted a handwriting analyst to testify, and provisionally barred a domestic violence specialist, while also ordering the next day's proceeding closed to the public. So, like I said, the judge ruled that Molly Amon, a behavioral threat assessment specialist, may not testify during the prosecution's main case and cannot offer opinions implying Richins' guilt. However, Amon will be allowed to appear in rebuttal if the defense presents generalized theories about how violent crimes typically unfold. Amon's proposed testimony relies on the Pathways to Violence model, which outlines behavioral stages that may precede targeted acts of violence. Defense attorneys challenged the framework's scientific validity, presenting testimony from criminologist Dr. Brianna Fox, who described it as lacking robust peer review support. Now, the judge concluded that the model is not sufficiently reliable to profile the defendant or establish guilt, but could assist the jury in evaluating broad defense claims if those claims are introduced first. Now, a handwriting expert was permitted to testify. Now, the court rejected a defense challenge to handwriting examiner Matt Throckmorton, who analyzed documents linked to alleged financial misconduct, including a power of attorney. The defense argued that the handwriting comparison is inherently subjective and that Throckmorton could not conclusively identify the author. The judge found that the expert's qualifications and methods satisfied admissibility requirements and noted that the Utah allows jurors to independently compare handwriting samples and determine the weight of the testimony. Then we have a domestic violence expert that was excluded for lack of foundation. Now, the prosecution's proposed domestic violence expert was barred from testifying at this stage of the proceedings. The judge determined that the state had not yet established a factual basis showing that Eric Richins was aware of any prior alleged poisoning attempts by his wife or that the relationship involved domestic abuse. Without such evidence, the judge ruled the testimony would encourage speculation and create substantial risk of unfair prejudice to the defendant. The ruling remains subject to reconsideration if the prosecutors later present supporting evidence. Now, the conclusion of today's hearing, the court granted a defense request unopposed by the prosecution to close the other hearing on Wednesday to close the hearing to the public. The judge stated that all rulings would nonetheless be placed on the public record. Additional pretrial motions concerning documents, recordings, and other evidence are expected to be addressed in those upcoming proceedings. Now, Kouri Richins faces charges of aggravated murder in connection with the March 2022 death of her husband, Eric Richins, when prosecutors alleged she killed him with a lethal dose of fentanyl to obtain life insurance benefits. Trial proceedings will continue. The judge made the right call, in my humble opinion. First, handwriting expert. Not a big fan of handwriting experts at all. They're up there with fingerprint analysis as well. You and I could be fingerprint or handwriting experts because they'll say, oh, if you look at a little squirrely, it could be the same. You know, it's totally subjective. But guess what? The jury gets to make their own decision as to how that is going to play out. As it relates to the domestic violence and basically the profiling that the defendant, Ms. Richins, is somehow a killer, or the domestic violence stuff, that should all stay out. Now, if the defense opens the door, it's appropriate for rebuttal testimony in their case in rebuttal. But anything that, tries to say that, this is the profile of somebody that would kill somebody, no expert gets to come in and do that. That's nonsense. And, frankly, the prosecution should be a little embarrassed, actually, for bringing that motion. And then the classic DV cycle of violence stuff. Jurors don't need to know all that nonsense. I'm not saying it's not for real. I'm just saying they don't need to know that. They just simply have to know whether, and their job is to find out and conclude whether something took place or not to somehow get a DV 101 class at a jury trial. And most of those experts are so biased. Everything is domestic violence under their little theory. And that's how they get paid. They literally get pulled off the shelf. Oh, we need a DV expert. Oh, we need the cycle of violence expert. They bring them in. They're on contract. It's disgusting. Anyway, we'll see how the Richins case comes out. Who knows? She may have a chance. Next on the docket, an Oregon man pleads guilty to second-degree murder in his girlfriend's death. That's right. An Oregon man has admitted to fatally shooting his longtime girlfriend and transporting her body in the trunk of her vehicle before a single vehicle rollover crash revealed the crime. Please meet Tyler Holman. He entered a guilty plea to second-degree murder with a firearm in the killing of 35-year-old Ashlee Buzzard. Now, according to the district attorney's office, plea agreement resulted in the dismissal of additional charges, including the unlawful use of a weapon and abuse of a corpse. And under Oregon law, a second-degree murder conviction carries a mandatory life sentence with a minimum of 25 years to be served before he is eligible for parole. Now, apparently the couple had been in a relationship for more than a decade and shared a young daughter together. But court records indicate that Gandolfi reported domestic violence incidents involving Mr. Holman back in March of 2024, describing physical assaults that left her injured. Neighbors recalled hearing heated arguments, and a family member noted concerns about Holman's alcohol use contributing to escalated tensions. Although assault charges were initially filed, they were later dismissed after police were unable to maintain contact with Miss Gandolfi. Classic, right? She's not going to go to court. She loves him now. She also maybe have nowhere else to go. classic domestic violence stuff, right? Anyway, the fatal incident occurred back in January of 2025, and prosecutors allege that Mr. Holman shot Gandolfi and placed her body in the trunk of her car. And then on January 27th, he lost control of the car and caused it to roll over in the accident. Emergency responders discovered Gandolfi's remains in the trunk, and subsequent autopsy confirmed that her death resulted from a gunshot wound unrelated to the crash. Anyway, Mr. Holman survived the accident with injuries requiring hospitalization and was taken into custody upon his release on January 30th of 2025. Court appearances in the following months showed him using mobility aids due to the crash-related injuries. And during a February hearing, Gandolfi's mother, who had custody of the couple's daughter since May of 2024, urged the court to deny bail, expressing grave concerns for her family's safety. She stated that releasing Mr. Holman posed a serious risk, emphasizing fears that the might target the family or the child as well. A second individual, 38-year-old Logan Wilkins, was also charged in connection with the case for allegedly assisting in the handling of Gandolfi's remains. Wilkins pled guilty back in March of 2025 to second-degree abuse of a corpse and tampering with evidence. His sentencing is expected to proceed now that Mr. Holman's case has been resolved because, they wanted him to testify before he got the benefit of a reduced sentence. But since he pled guilty, well, he doesn't have to testify. What can you do? Shoot somebody, let's take her in a car. Let's go drive around. Well, unbelievable, ladies and gentlemen. Telling you, you can't make this stuff up. Next, the Louisiana Supreme Court. Here's a case for suspending a judge over some ethical violations. Probably not a judge that has the judicial temperament to, be a judge, because she needs judicial temperament. The Louisiana Supreme Court convened on Tuesday to consider disciplinary action against Shreveport City Court Chief Judge Shiva Sims, with prosecutors urging a 1-year unpaid suspension for what they described as a pattern of judicial misconduct, including improper releases of domestic violence suspects and displays of arrogance in office. Now, the Louisiana Judiciary Commission has charged Judge Sims with multiple ethical breaches, asserting that she has demonstrated a persistent disregard for legal standards and judicial decorum. Special counsel Michelle Beatty argued before the court that the allegations reflect a clear pattern rather than isolated incidents, emphasizing that Sims' 14 years on the bench and prior disciplinary record means she should know better. Now, Beatty characterized the judge's conduct as symptomatic of black robe-itis, a term for perceived judicial overreach, and contended that Sims has operated her courtroom as a personal domain. This marks the latest chapter in Sims' disciplinary history. Back in 2015, the Louisiana Supreme Court suspended her for improperly urging In 2015, the Louisiana Supreme Court suspended her for improperly using contempt powers, and in 2016, she received an admonition for chronic tardiness in court proceedings. I always think that's funny. Judges show up late, no big deal. You or your client show up late, you could be held in contempt or even arrested. Anyway, this case stems from an investigation that identified several categories of misconduct, supported by clear and convincing evidence, according to the court documents. Now, among the most serious allegations is Sims' handling of bond decisions in criminal cases. The commission claims that she repeatedly released defendants charged with domestic abuse or battery and other crimes of violence on their own recognizance in violation of state law, which explicitly prohibits such releases for these offenses. Well, the retired Louisiana Supreme Court Justice Joseph Blake was among those who raised concerns, alleging that Sims failed to adhere to statutory requirements in multiple instances. Additional complaints include Sims' use of court-provided vehicles for personal commuting over several weeks, with marshals directed to refuel it. Her reliance on independently obtained documents to challenge a witness's credibility, and instances of impatience and condescension towards litigants. One documented case involved an eviction hearing where Sims was found to have been unnecessarily discourteous to a pro se litigant, questioning her repeatedly in a demeanor manner and ruling in a way that appeared contrary to the evidence presented. Commission filings highlighted a lack of remorse on Sims' part, stating that her actions demonstrate indifference to judicial authority limits and ethical obligations. The prosecution initially recommended a 1-year suspension with pay and reimbursement of an investigative cost of about $11,000, though they now advocate for a stricter penalty without compensation. Now, the attorney defending Sims argued that many of the cited incidents occurred during good faith efforts to fulfill judicial responsibilities. And the attorney noted that the commission dismissed certain rudeness claims as unproven and suggested that any sanction, if imposed, should not exceed a 60-day suspension. Now, they acknowledged that alternative phrasing could have been used in the eviction hearing, but maintained that Sims was appropriately scrutinizing the litigants' claims. The 4-judge panel would need to redistribute Sims' substantial caseload, estimated at thousands of evictions and criminal matters annually if a lengthy suspension is imposed. The Supreme Court has not indicated when it would rule on that matter. Can you imagine a judge actually being sanctioned for not following the law? Oh my gosh, you can't release somebody on a personal recognizance bond pursuant to the law, and she does it anyway. A judge's job is to follow the law, whether they like it or not. They don't get to decide which laws they get to enforce for their own preference. Unbelievable. And judges need to have appropriate judicial temperament, because at the end of the day, everybody that goes in that front of that courtroom, whether it's a win, lose, or draw, should be able to say, I had a fair shake and the judge treated everybody with absolute respect. Next on the docket, this day in legal history, January 8th, 1790. President George Washington delivered the first annual message to Congress, helping to establish the constitutional practice of reporting on the state of the Union and recommending legislative priorities. Also on this date in 1973, 7 men went on trial in Washington, D.C., connected to the June 17th, 1972 break-in at the Democratic Party headquarters in the Watergate Hotel. That's right. And next on the docket, our legal quote of the day comes from Chief Justice John Roberts. He says, quote, I think judicial temperament is a willingness to step back from our own committed views of the correct jurisprudence approach and evaluate those views in terms of your role as a judge. It's the difference between being a judge and being a law professor. And finally, our dumb criminal of the day. In a tale that blurs the lines between fantasy and felony, a 40-year-old woman was arrested after allegedly attempting to live out her mermaid dreams. That's right, including tail, clothing, or permission in a neighbor's private pond. According to the Union Parish Sheriff's Office, Erin Elizabeth Sutton sparked alarms in the quiet Linville community last November when a homeowner reported her screaming in the driveway, despite repeated warnings to stay off the property. Deputies arriving on the scene discovered Sutton had upgraded her trespassing to full immersion. She was swimming naked in the complainant's pond, and when ordered to come ashore, Miss Sutton reportedly objected, explaining that she was, quote, trying to be a mermaid, end quote. After prolonged negotiations and presumably no appearance by Prince Eric, she finally emerged. Concerned about hypothermia in the chilly water, officers summoned paramedics and attempted to escort her indoors to warm up. That gesture of concern proved ill-timed. Police say that Sutton suddenly charged at deputies, ignoring commands to stop, and continued resisting even after the taser proved ineffective. The encounter developed into a physical struggle involving kicks and punches before she was finally subdued. Now, while being transported for medical evaluation, Sutton allegedly issued death threats to both deputies and the paramedics. Warrants were subsequently issued, and on January 6, she turned herself in to police. Sutton now faces charges including trespass and assault on a police officer. And local residents, meanwhile, report that the pond's fish population has declined, to comment on whether they found the uninvited visitor enchanting. All right, ladies and gentlemen, that's all we have for you today. Hope you enjoyed the show. We'll see you next time. And remember, the Constitution matters.